Dobar dan svima. I will switch to English. Our today's guest is Professor Katarzyna Miaskowska-Daszkiewicz. She's assistant professor in Catholic in the Faculty for Law, Canon Law and Administration of Catholic University John Paul II in Lublin, Poland. She's assistant professor there, and luckily for us, she received research, let's call it research visit, funds for research visit, and she picked up Serbia, Belgrade, and it's very lucky for us. So it is her third time in our institute. We have a quite close collaboration. We are already applied for one project. We are planning so much more. So we hope to see Katarzyna in future much more often here in our institute. And we are also hoping to go in Lublin, of course. So today's topic is no-fault liability in medicine related to Polish law. When I thought about our solutions, I found out, and we discussed it earlier, that our law is not so much close to no-fault liability in medicine, but there are some exceptional cases where there are. But let's leave it for discussion. What else? We have Katarzyna here in. We don't have so much publicity here, public, but all the people are first friends and dear colleagues from courts, institutes, and also I can see colleagues from the Institute of Public Health. So I think that is very good audience for you. Please. The floor is yours.
Thank you so much, Marta. As to the public, I always say the quality, not the quantity counts. So I'm very pleased that I can be here among my distinguished colleagues from the Institute of Social Sciences. Thank you so much. And of course, our colleagues from the audience. Thank you very much, Marta, for this introduction. And as you may already know, my backgrounds are in administrative law, and I am not an expert in civil law. To which the adversarial system of damages belongs. But my presentation today will go not into details when it comes to civil liability, but I would like to give you at the beginning the general characteristics of the Polish scheme of compensation for medical damages. So if I may ask for the presentation, is it already? Thank you so much. Thank you very much for your help. In a matter of fact, this is a problem. It's the answer of the question of choosing between the judicial and non-judicial system, judicial model, and the medical liability in Poland is built on two pillars, as you can see on this slide. Firstly, on a system implemented by civil courts based on civil law, but the basic prerequisite for this pathway to get the compensation is to establish the fault of healthcare providers. This is, of course, associated with lengthy court proceedings, as you may see, in potentially two instances, because according to Polish Constitution, Article 78, each party has the right to appeal rulings and decision issued in the first instance. And of course, it's always also also, I would say, cursed this proceeding with costly expert opinions, with the fees for lawyers and search for evidences. So cost of civil proceedings cannot be seen only from the perspective of time, of course, because indication and initiation of civil process in Poland is also connected with some cost of civil process. It's actually a high amount when we thinking about the costs. It's at the start point of the process, 5% of the value of the subject matter of the dispute, just at the very beginning to the party. And of course, secondly, we have on the second part of the slide an administrative legal system, and it is implemented by a public administration body, which can be triggered as soon as it has been objectively established that a medical event has occurred and that damage has been caused as a result. And this is without the need to investigate of the fault on the part of healthcare providers. And I only a word of commentary to this point, because we are now in transitional period in Poland, since until the end of June 2024, no-fault liability is being implemented by 16 commissions, so-called Provincial Commission for Assessment of Medical Events. We have 16 commissions in each province called województwo. And in this out-of-court model, in the proceedings before the commission, it still is during this 1 month left, it is to determine whether a given harmful event is a medical event. And the commission did not award compensation benefits, but once the ruling of the determination of existence of a medical event became final, the compensation offer is to be made from a medical event insurer or in absence of insurance, because in Poland it's not mandatory, by a hospital. And the negative point of this proceeding was in practice that the offers from the hospitals oscillated around very underestimated amounts. Even €1 offer, it was also a legal offer according to the law. And as a result, patients, as you can imagine, rejected this offer and took the claim to the court. But the commission model as such began to be regarded as a prejudgment one, or even as a hunting for evidence, because at really relatively low cost, it was possible through this proceeding before this commission to prepare for the court battle, which means the court was not bound by the finding of this commission, but the party initiating this litigation had at this disposal, thanks to this proceeding, to this administrative one proceeding, the opinion of experts, testimony of witnesses, and the reasoning behind why the commission accepted the incompatibility of a given procedure with current medical knowledge. And as of July this year, the 16 commission are disappearing, and one single central commission will be established under the patient's ombudsman. So it will be one central body. Of course, this change provokes a question about the future, about the efficiency and the accessibility of this procedure for the patient. But we have to wait now until the end of the year, at least for the first assessments of this new proceeding, but I will talk about this later on. So returning briefly to the theme of civil liability, in order to outline the attractiveness, actually very high attractiveness of the no-fault model against the background, it is necessary to indicate the ground for claims according to civil law. And system of compensation for medical damages currently in Poland includes, as you may see, compensation for disruption of health and injury to the body of the directly injured person. Second one, compensation to relatives for the death of injured person. And the new resolution since 2021, the compensation to the immediate family member of a person with whom a family relationship cannot be established or continued as a result of the tort. So this is a new regulation in Poland since 3 years. And in the case of civil liability, the amount of compensation was left to the judge discretion, and the possible amounts to be awarded can best be seen from the examples in the judgments. I will just show you briefly a few examples so that you can get this impression how much can we get in the court when it comes to civil liability. In this first case, it was the highest compensation in Poland ever. And it was the judge in second instance judgment was in 2014. In this first case, the patient was admitted 2004 in the Central Clinical Hospital in Warsaw, not in any rural region. This patient has a heart attack, and she stayed for a couple of months in this hospital in Warsaw, and she came out with ruined health and with incapacity for independent existence. She was granted a group 1 of and she was suffering from so-called intercostal neuralgia after heart attack. And the doctors decided to give her an intercostal nerve block pain, just one simple shot. But in this process of the block, food salmonella was implemented into her spine. So let's imagine. And this caused her to develop a supradural abscess, irreparable damage of her spine, and of course, leg paralysis and permanent urinary problem. It was not all the medical mistakes in the hospital, but this hospital has a really bad luck because this patient was former, since 8 years, a legal advisor in this hospital. So she knew very well what to do. Then she went to the court and the case dragged on for 8 years at first instance. In 2012, district court in Warsaw awarded her 5 million Polish zloty, which is amount 1.5 million euros compensation of damages. And the hospital appealed, of course, to the Court of Appeal, and the Court of Appeal in Warsaw finally settled that this case in 2014, and it was found that it was a really result of doctors' errors and hospital negligence that the woman had suffered permanent damage to her health. It was a historical judgment. As I mentioned, that it was the highest compensation for now in Poland. And so, of course, in my opinion, all through this judgment strengthens the protection of patient rights by setting fairly high limit for this compensation of loss of health. But at the same time, it can be called, after this 10 years battle in the court, a Pyrrhic victory. In any case, another well-known approach is in such a type of cases matches perfectly here, namely, as you may know, justice delayed, justice denied. After 10 years, the patient has to spend her own money during this period for the rehabilitation. The second example, as you may see, there are particular type of medical damages, namely neurological perinatal damages. They arises in connection with or as a result of childbirth in neuropathological nature. And these damages are characterized by irreversible nature of damage and the fact that the cost of medical care, which sometimes lasts of the entire life of the child, is very high. This perinatal damages are an example of damages generating the probably highest cost and highest compensation amounts, which means from the point of view of liability insurance, they are hard to insure injury. And in Poland, amount of compensation for perinatal damages oscillating between €500,000 until 700,000 euros. And just shortly, third case, the patient in this case was not adequately informed about the risk associated with the administration of contrast prior to MRI examination. And it turned out that the patient was allergic to the contrast agent, and she was permanently paralyzed after this injection with contrast. And she gets almost one quarter million of euros. I will not go to this fourth example. I found it very interesting because I found only 3 cases in the world, in Poland, in Italy, and in USA, with such damage, as you may see. And in Poland, the cost from the side of hospital, it was, I don't know, only or so high cost as 60,000 euros. But as I said, turning to the no-fault model, it has to be pointed out that nowadays we have in Poland 3 independent tools, namely compensation from the medical events compensation fund, compensation from clinical research compensation fund, and the third one, compensation for immunization compensation fund. And this compensations from all these 3 funds are decided by the patient ombudsman, which is a central administrative body in Poland, by means of administrative decision in the administrative procedure. And this administrative decision can be appealed before an administrative court. Oh, I'm so sorry. I did something wrong. I had to ask for help. Thank you so much. So let me go to this first tool of no-fault liability. Nowadays, as I mentioned, we are in such a so-called transitional period until 1st of July. We have still working 16 commissions, but now we have created a new system, and this new system starts from the 1st of July this year. And due the creation of public compensation fund for victims of medical events, the Polish off-court model has been very grandly transformed. And first, the definition of a medical event has been amended, indicated that it's a legal definition. This is any event in the form of infection, bodily injury, disorder of health, or death, as long as it could have been avoided with a high probability if the health service have been worked in accordance with current medical knowledge, or if another available diagnostic or treatment method had been used, unless there were foreseeable normal consequences of the method, of course, to which the patient gave informed consent. As an example for this medical events could be infection of a patient with hepatitis C during hospital stay, or doctor making or a wrong diagnosis from the doctor's side, or just very well known, I think, over the world, leaving a foreign body in patient's body during operation. And proceedings before the patient ombudsman will end with, I said will end because it starts from July this year, will end with administrative decision establishing the existence of medical event and either awarding a certain lump of sum of compensation or denying such a compensation. And application costs are about 70 euros now. Earlier, before this 16 Commission, the costs were nearly the same. It was about 50 euros for application. And this medical events compensation fund covers medical events that have occurred in hospitals. In any hospital, which includes hospitals, psychiatric ones or spa hospitals, but it has to be in connection with the provision of publicly funded healthcare services. And that's the point in this tool. Among of other things, the guarantee services financed by Polish National Health Fund. This means actually that this compensation tool is not applicable to the case of medical events in individual medical practitioners or hospitals, in the case of medical services paid with patients' funds, so in the private sector. And the compensation amounts for this tool ranges are set by law. So we have the highest and the nearest level of compensation. And as you may see, the amount of compensation for a patient who has suffered a bodily injury or disorder or has succumbed to an infection is in between 470 euros or for 47,000 euros. And on the other hand, close relative of deceased patient who has made a claim may receive between also 470 euros and 24,000 euros. Okay, let me go to this second tool, compensation from the Clinical Research Compensation Fund. And this fund covers damages arising from participation in clinical trials, but only initiated after 14 April 2023, which means after the entry into force of Polish Act of Clinical Trials on medicinal products for human use, which of course sets limit only to damages arising from participation in clinical trials of medicinal products for human use, not in every clinical trials conducted in Poland. And from this funds from this fund, from resources from this fund, the patient's ombudsman awards, of course, also in administrative way, compensation up to 46,000 euros in the event of injury to the health of clinical trial participant, and in the event of his or her death as a result of participation in clinical trial, the benefits is up to 23,000 euros for each of his or her relatives. And when it comes to compensation fund from the Immunization Compensation Fund, this fund covers COVID-19 vaccination carried out as a part of national immunization program. In Poland, it was not mandatory immunization, but it covers also vaccination against vaccination given in compulsory immunization epidemic vaccination program carried out from 1st of January 2023 and onwards. And the condition for compensation in this from this fund is a result of vaccination of an adverse reaction listed in the summary of product characteristics of the vaccination and concerned which has caused the need for a hospital stay at least for 14 days, or the occurrence of anaphylactic shock necessitating observation in hospital emergency department or emergency room or hospitalization, and here of actually any length. And the amount of this compensation varies, range from 700 euros to 24,000 euros, of course, depending on the duration of the hospitalization. And until now, as statistics shows, I checked this today, this compensation fund gives about 5 million Polish zloty, which is 1,200,000 euros in 250 cases. So it's really it works. It works for now. But interestingly, there is no compensation foreseen from this fund when it comes to the death of the patient as an adverse event after vaccination. So this is excluded actually from this fund and from this act, according to Polish law. And what is interesting, as we also know, the vaccination against COVID-19 actually are on the market under this special regime. It was so-called conditional market authorization, and the characteristics of products will actually vary from month to month, because we will add, after each part of this fourth actually phase of clinical trials, we will add another adverse event not known 1 year ago. And as far as we know that new adverse event is on this characteristic of medicinal product, we may claim, according to the law, for this compensation from this fund. And where are we now in Poland? What is the situation right now? Actually, I believe that we are still not fighting mistakes, but we are still fighting people who makes mistakes just by nature as such. And the system right now, as I may say, still seeks for guilty ones. We have to have someone who's to show his or her guilty. And it seeks justice, and it steals fear and penalize. And at the beginning, to have a functional impact on health protection, I have to say that it's really have a huge impact, because last year 66% of specialization procedures in surgery were not staffed under less recruitment for this procedure for medical specialization, because the doctors are simply afraid of becoming surgeons due to legal liability which may accompany with this profession. And it's really problem in Poland now. And more importantly, this guilty first system block actually the development of science of medicine. Let us try to imagine that we will blame a pilot for every aviation catastrophe. If such system was introduced, we would not only fly planes anymore, but the pilots would be simply afraid of flying. But such an event, we don't have such an event in the case of aviation, because the investigations covers the entire chain of events, and analysis of the entire chain of events allows the system to learn from existing mistakes and eliminate faults at the same time. How should we actually create a factual system of treatment safety? How should we create the system of, I would say, a new approach of liability? I think primarily by establishing a fund of compensatory medical events, which will be open up for extrajudicial avenue, extrajudicial path for compensation, not only for those injured during the stay in the public hospitals, such a system we have now, but also in emergency medical case, as well as outpatient specialist care centers, primary care, also privately financed, which is very important. And secondly, I think we have to introduce a register of adverse events to which the doctors could and want to register, want to report, without any fear what will happen next and what come next to them. As of July 21st in Poland, we have an obligation to report medical event, but this obligation applies only to the doctors in public funded health services. And it has to be more wide, more open for the rest of the doctors who's just exercising their job also in private sector, which is huge in Poland. And thirdly, I would like to say that we have to change the principles of responsibility of medical professionals, which is not to be mistaken, of course, with impunity. It is not my point. I think the administrative liability, no fault liability, is very, it's very, I would say, attractive one for the legislator, because it's objective in its nature. It consists in the fact that administrative liability is detached not only from the fault, but also from the person of the offender. And it's pretty easy to establish such a system, but it has to be open and covers not only public sector, but also private one. I will end at this point. I will thank you for your attention. Of course, any comments or any questions are very welcome. Thank you very much.
Thank you, Katarzyna. I forgot to stress that Katarzyna her background is administrative law, but she also works a lot in the health law, and she's also a consultant expert for Polish Parliament. So she sees things, I would say, a bit from the hill, not not only from the ground. So these are all very relevant hints for us, I would say. And before questions, I have several, but I'll let you pose the questions. I would say that notion of no fault liability in the Polish system is different than what we consider. So there's no fault liability, but let's discuss later if somebody has some questions before. Yes, Marco, please.
Good. Many thanks, Katarzyna. Very insightful lecture. I learned a lot, and it's a very interesting. I mean, for us as administrative lawyers, this is very interesting, especially coming from a jurisdiction where you don't have this kind of a compensatory system, which I find very useful and very good for patients. So few things. I would like to ask is, first, this transfer, when you first go through administrative route and then you turn to a civil route, which is very interesting. Do people normally take the administrative route first because it looks more effective? It costs less and it lasts shorter. Then the question of, because you mentioned that patients' ombudsman will now be in charge in resolving these cases. So what are the other competencies of the patient's ombudsman? Is there going to be a kind of a confusion? Are there some inspectorial or oversight or monitoring powers of the ombudsman, which will now have these adjudication powers as well? So is there going to be any kind of a confusion, or this is like completely divided? And then the third question is compensation funds. So these compensation funds are publicly funded. So the money comes from the budget, or did I get it right? Because you said that they are compensating only for events that occurred in a public sector, basically. So in the context where it is funded from the public fund. So what happens with the services and events in a private sector? I mean, because this kind of leads to this situation in which you are less less secured if you are going to the private sector rather than a public sector, and then it doesn't put institutions on a level playing field to that extent. Okay, I'll stop with this.
Okay, thank you so much, Marco, for your questions. I have to admit I did not wrote the first one. Can you be so kind and repeat?
So this transfer from, so you
Oh,
first take
I know.
administrative route, then you take.
Now
it
I know.
to-
Mhm, mhm. Thank you so much. Okay, as to the first question, both of these procedures are competitive, which means you can choose. But now, as I may, some a sound of Polish awareness when it comes to this system. Polish society is not aware. It's not aware enough when it comes to this possibility of compensation from this compensation fund, and earlier, 1 month now, from this funds administered by the 16 commissions. So it was not very often that people going firstly to the commissions, and I'm afraid we'll have to work more on the side of awareness of society that there is such a possibility, faster one and more efficient, and also not so costly, that this liability in courts, proceeding in courts. So if I had to just give you a simple answer to your first question, I would say the people are not going very often, and they are not choosing very often this path to get the compensation. But it should be changed. I don't know whether it's a good idea to establish the 16 commissions because it was easier for people to go, let me say, 100 kilometers and not 500 kilometers to Warsaw, because now it will be this case. The people have to go to Warsaw and maybe to undergo an examination. I don't think it's a good solution. I think we have to change this, but firstly, let's start to work this system, this new system with only one commission. When it comes to ombudsman for patient rights has many competences in Poland. One of this competence is a competence to give this administrative decision regarding to compensation, but there are also many other competences also connected with powers. Namely, there are also decisions made by this ombudsman in the case of injury of collective rights of patients, which means each patient, even a potential one, when he goes or her goes to this hospital, to this facility, will be injury in his or her right because of rule in this hospital. Maybe it could be a ban of additional help from the relatives, and it will be for the ombudsman of patients enough to get this administrative decision that collective patient rights are damaged in this facility, in this hospital. And I don't think that this new additional competence of administration of these 3 funds will be too much and will be, how would I say, would interfere with other competences of ombudsman. But it's one body, it's one person, central. It could be problematic when it comes to the amount of claims, but I think we will face with it maybe at the end of the year. But maybe I think about this wrong. Maybe it will everything goes smoothly because of, I don't know, the method of dividing the competences between the employees of the ombudsman. We have to wait until the end of the year and check whether is a problem with it or not. And as to the compensation funds, as I understood your question right, you asked about the sources of the funds, of the money, and it comes to which fund we have to we are taking into account. When it comes to this normal compensation fund, so-called normal compensation fund, with this medical events compensation fund, the resources are from a central budget. So that's why maybe that's the reasoning that covers only medical events which occurs in public finance facilities. When it comes to the fund of clinical trials, it's money. It's money that are from the investors from these medical trials, main investor, investigator also. So it's from actually pharmaceutical companies. And when it comes to vaccination compensation fund, immunization compensation fund, it's also from the marketing holder authorization from this vaccinees. So there are several sources to cover these funds. I don't know whether I asked your questions.
Yeah, thank you very much for the excellent speech, and I really enjoy and have very get inspiration to discuss something. Actually, I more read from French literature about this kind of composition, and it is I think similar because they have also a national commission for this event, medical damages complaint, and what I want to ask you is how long this kind of compensation, not compensation, is practiced in Poland? How long? How many years actually? And a second question is, what is the connection between liability insurance and these issues, especially when you talk about clinical trial? It is interesting maybe to hear what's about this connection. It is the same or different? I think that probably it is different compensation.
Thank you, Harriet. Can I answer this? Okay, thank you for your questions, Harriet. Firstly, since when do we have in Poland this compensation system? We started 2008 with the 16 commissions in Poland, in the 16 voivodeship commissions for this no-fault liability systems. And we have started with compensation fund for vaccination side events since 2023. But it goes not only pro futuro, but also but also back, because we established this extra regulation to damages which are resulting from vaccinees, COVID-19 vaccinees. We get these vaccinees at the beginning of 2021. And this compensation fund starts 2023. So 2 years back, we can claim for this damages 2 years back. But it's really extra regulation only for this case connected with COVID-19. And the fund for clinical trials, it starts from April 2023. So it's really new solutions now in Poland. But this common normal, so-called normal system for this public finance hospitals, we are practicing this from 2008. So we have some how to say it? Oh, I look at Marta because she's always helping me. We have, okay, no, I won't, thank you. No, we have collect some impressions, so now we can only improve it. I don't know whether this path is really an improvement to exchange the 16:1, but we will see, as I said. And when it comes to the compensation connected with clinical trials from this compensation fund and compensation from insurer. Yes, it was your question. It's not competitive. So which means we can get compensation from this compensation fund and from the insurer. So it's pretty not connected. It's really separate. Yes, we can accumulate these compensations. Yes.
I wanted to ask you, I mean, until somebody else think about questions, first, we had, do you think altogether this system is relief comparing to the civil system, to the actually court proceedings, judging, and so on? Because I think somewhere 90s, Germany first introduced this Hilfe Gesetz. I think they were the first that introduced, and then France. They were the first that introduced the law that would actually help damaged people, damaged by some cause, in this case by HIV infection, caused by, let's say, blood transfusion or caused by this therapeutics containing blood, that helps them and supports them in compensation, not by not going to court and proving all the issues and so on. We were, when COVID was going on, there were some thoughts for introducing COVID compensation, not just for vaccines, but also catching COVID in the non-COVID hospitals. Why is it non-COVID if you catch COVID? But of course, so far it was not implemented. So do you find it a relief as potentially a damaged person? Is it really shorter? Doesn't matter if it's 1 commission or 16 commissions. Is it really shorter, simpler? How much do you have to prove in this procedure? Is it also acting against medical standard, the damage causal link between these two, or the proving in the procedure is somehow shrinked and the applicant is a bit relieved from proving things? Or how do you feel it? What is your impression on it? Is it really helpful to the damaged persons, or
yes? I stole the microphone, but
yes,
maybe you would ask something more. Okay, thank you, Marta, for your question. Actually, it was developed with this assumption. It should relieve the system as a whole, because as you may see, I don't know what is what is the situation in Serbia in this circumstances. I mean, the length of a civil trial in courts. In Poland, it's about 4 or 5 years in first instance. So it's a long way. It's a long journey for a patient. And of course, during this process, you have to also twice revive your trauma connected with this situation. And it should be also relief for the patient. And I think when the society will be more aware of this possibility, because of the terms and of the in terms of administrative procedure code, which is very helpful for the parts of this procedure, because it's really administrative one procedure. It's a procedure in which we don't have this rule, ignorantia juris nocet. Before the administration, ignorantia juris non nocet. You have to just follow the employees from administration, and they had to inform you about everything. So I think it would be very big relief if people know that such a system exists, and you don't have to give them the exact expertise. You don't have to pay for this expertise, because the experts they do it before this commission for public money. So it will be big relief if it's really starts to work 100%. So I am truly convinced about it. Yes.
But as an applicant, as a damaged applicant, are you going through this system towards hospital or towards natural person physician? You're going with your application towards hospital that, let's say, made the damage.
For now, yes. For now, yes. But we are thinking also on this level of parliament that we should expand it, and the system should also cover private sector and the medical professionals which are carrying out their professions in private practices. In this one nurse or one doctor, one physician practice, because for now it's only shrinked to hospitals. But we will think about to extend it. Mhm.
I thought maybe physical persons within hospitals, so physicians that work in hospitals, they are not the object of, let's say.
No.
Just hospitals.
No, just hospitals.
Okay, maybe as a legal entity.
Yes, but the error of the physician can lead to the damage, and the physician is an employee in this hospital, and it goes, yes.
And third question, why is that excluded?
I have no idea, actually. I was really wondering.
Related to COVID.
Yes, of course, I was wondering, but it was also a surprise for me that it's actually excluded, but not maybe not excluded wordly, but it's not mentioned. No, it's not included. It's not a word about it in this act. Maybe it would be too much for the budget. I don't know, but I didn't saw legal reasoning for this exclusion. Yes.
That's not really
Appeal for the building. I have two questions. If you have information about how many cases are taken under the courts of Poland when it comes to malpractice, medical malpractice, and are they often, I mean, numerous or rare, seldom? And the second question, what is the length of these cases usually? Is it 1 year, a few years, or 10 years or more? So I want to compare it with the situation in Serbia.
Thank you very much for this question. Yes, according to statistics, each year we have about 2,000 cases when it comes to medical liability. But only 30% of these cases are ending with success for a patient. So we have to take it also this into account when we talk about this no-fault scheme in Poland. And the length of this rulings of these proceedings are about 4 or 5 years in one instance. Thank you.
Okay, so you're faster than us. Okay, but it is average. It is average.
In Serbia, average length of procedure is longer than. I think, I mean, this is my opinion, and, yeah. Thank you.
Thank you. Are there any more questions? Yeah, comparing the situation in Poland and getting angry. Okay, thank you very much. I think that it was very inspirational, and especially in the lecture, and especially in the part when it comes to pre-step to civil proceedings, not only from the corner of patients, but also from the corner of physicians. There are also for years in the court, from the corner of judges that are getting their decisions back for several times, and so on and so on. And this is also quite an expenditure for the state as well. So I believe if I'm just sorry that we didn't have more people here, especially people from legislation, and who can decide on the issues such as, I mean, we have ombudsman as well, but this is not in its competence. So it might be valuable to think about widening competencies or funds, and we had several occasions thinking about it, but none of it actually resulted in some clever solution.
It took also many years in Poland.
Yes, okay, we'll have this example for our future lectures. And thank you very much, Katarzyna. Thank you, valuable. And I hope we'll see you here many times.